This is our 117th meeting, and it's a real pleasure. I'm Gregory Schaefer. I'm the president of the American Society of International Law. And if everybody could start to take their seats, we can get to our substantive program, which I'm really looking forward to hear. Yeah. Great. I'll call you up in a moment. I'll just, yeah. So, you know, this is incredibly exciting to welcome you here this evening to Washington, D.C., to join this community of ours, of international lawyers. We've traveled around the globe to be part of this convening for 4 days of amazing programming, outstanding speakers, timely discussions, and most importantly, a chance for us to see each other again after all these years. If you're new to the Society, I encourage you to become a member and take advantage of the Society's rich programs of events, publications, and research. It's an amazing group of international lawyers. I especially want to welcome this evening's distinguished guests, Professor Kim Lane Scheppele of Princeton, and our 2023 Grotius Lecturer, Justice Manuel José Cepeda Espinosa, our distinguished discussant, and Dean Roger Fairfax of the American University Washington College of Law. The topic this evening, restoring democracy through international law, could not be more compelling given the challenges that we face as citizens around the world today. There are no more discerning speakers on this topic than Professor Scheppele and Justice Cepeda. ASIL is proud of its long partnership with the American University Washington College of Law. For these now 25 years, a quarter of a century, of this important contribution to this field of international law, I especially want to thank the contribution of my friend Patty Dalai. It's been years. We started off in an interest group in the Society where I was an untenured junior professor. She welcomed me at that time, and I remember that. And I just thank you so much for everything that you've contributed, obviously, to the field, the broader field of international and comparative law, and to this program in particular. So thank you. I want to, at this point, introduce Dean Fairfax, who will share some welcome remarks, and we'll introduce our two keynote speakers. Dean Fairfax is Dean of American University Washington College of Law. He's a prominent legal scholar, educator, and nationally known expert on criminal justice. His scholarship appears in numerous books and leading journals. Prior to his career in academia, he practiced law with the international law firm of O'Melveny and Myers, and served as a federal prosecutor through the Attorney General's Honors Program and the Public Integrity section of the Criminal Division of the U.S. Department of Justice. After graduating with honors from Harvard College, University of London, and Harvard Law School, he was a law clerk for Justice Pat Saris of the U.S. District Court of the District of Massachusetts and for Judge Judith Rogers of the U.S. Court of Appeals for the D.C. Circuit. He's central to our evaluation now today of the Supreme Court and all the challenges that it has faced. He was appointed by Chief Justice Roberts to that entity. And so I just thank you for all of your work, and I thank you for being dean and sponsoring this important partnership for international law and for the Society. Thank you.
Good afternoon. This is ASIL. We could do better than that. Good afternoon. All right, wonderful. I want to thank President Schaefer for that kind introduction. And on behalf of the American University Washington College of Law and our International and Comparative Legal Studies program, welcome to the 25th Annual Grotius Lecture. And I want to begin by thanking those responsible for organizing this fantastic evening, including the American Society of International Law, obviously President Greg Schaefer, Executive Director Michael Cooper, I just met him, and the ASIL staff who are working so hard to make this such a wonderful convening. And I also want to thank my colleague, Professor Padadea-Lai, and all of my wonderful colleagues here, including my predecessor, Claudio Grossman, and so many others who work in our international programs at WCL. I want to thank them for their help in coordinating this event. WCL's commitment to promotion and protection and development of international law and to a global outlook, they remain as strong as ever. A quarter of a century ago, the International Legal Studies program at the Washington College of Law approached ASIL to suggest a public lecture at the beginning of the ASIL annual meeting. And the rest is history. The intention was to have this as a public lecture for not only those registered or regularly attending the annual meeting, but for the wider community. The hope was to broaden the interest and participation of voices in international law. And our international programs at WCL recently celebrated 40 years of commitment to international law and international education. And surely, current world events show that the community of international law scholars bears a special responsibility to the global community in securing peace and justice. The topic of the lecture today cannot be more relevant: restoring democracy through international law, by our distinguished lecturer, Professor Kim Lane Scheppele, and our distinguished discussant, Justice Manuel Cepeda. And Dr. Scheppele is the Lawrence Rockefeller Professor of Sociology and International Affairs at Princeton University. She's clearly a rock star because I tried to meet her just before and she was surrounded the entire time, so hopefully I'll get a chance to share some words with her after her lecture. But I see why. She's a member of the American Academy of Arts and Sciences and the International Academy of Comparative Law. She received the Calvin Prize for influential socio-legal scholarship from and is a former president of the Law and Society Association. She was a professor of law at the University of Pennsylvania Law School for a decade and has been a visiting professor of law at Yale and Harvard and a number of universities across Europe. And she will be joined today by our distinguished discussant, Justice Manuel José Cepeda Espinosa. And Justice Cepeda is a former member of Colombia's Constitutional Court, where he was just not a member, he served as Chief Justice. And he's also a current member of the high-level panel of legal experts on media freedom. He served as the counselor for the government of Colombia for the territorial and maritime dispute Nicaragua versus Colombia, the case before the International Court of Justice. And Justice Cepeda's government service includes time as the presidential advisor for the Constituent Assembly of Colombia, ambassador to Switzerland and to UNESCO, and service on the team of transitional justice experts who negotiated the peace agreement with the FARC. And he's an emeritus president of the International Association of Constitutional Law. So without further ado, let me invite Professor Scheppele to the podium to honor us with the 25th Annual Grotius Lecture on International Law. Thank you for being here and enjoy the lecture.
Well, hi. So I think... You could microphone. This is for short people, have to move the microphone. Okay, well, thank you so much for that lovely introduction. I'm really honored to be here. I'm also especially honored in light of the fact that this is always an association that I have long admired, and the program committee and the folks who are putting together the program this year is really a team that I'm particularly honored to have been selected by. And I'm also really honored, in particular, to have as my commentator today, Manuel Cepeda, because as you'll see when I get into this, it turns out that actually he was the inspiration for this lecture, so in many ways he should be the lecturer and me the commentator, so we're going to have a little tag team here, and I think he'll explain in his comments why it is that a lot of his work has been the inspiration from what I'm about to say. Okay, now what I need to do is find a clicker. Clicker? Is this a clicker? Do we have a clicker? Because I have slides, I have to figure out how to move them. Has anybody got a, oops, I think somebody's running up. Okay, sorry. We didn't rehearse this part.
That is it.
Oh, that is a clicker?
So then advance.
Oh, that's on a microphone. Okay, thank you. Okay, so I'm going to move the microphone a little bit. Can you hear me if I'm standing over here so I can see my own slides? Okay, so first, this is the Grotius lecture, so let me say something about Grotius. So this is apparently the 25th Grotius lecture, and he would be 440 if this were his birthday. Which is to say that if he were writing now, or if he were living now, he would be extremely surprised in some ways by the question that I want to raise today. And yet, you know, you go through all of his works. He actually wrote an essay on the Dutch Constitution, which I have not been able to find. If any of you know how to locate it, I've contacted Dutch colleagues, law librarians. But what I found instead, in going through his work, was a quotation that I think is relevant today, both for the ambivalence it expresses and for the hope it expresses. And it's from, of course, his most famous work. And he wrote that a people can select the form of government which it wishes, and the extent of its legal right in the matter is not to be measured by the superior excellence of this or that form of government, in regard to which men hold different views, but by its free choice. So what is he saying? He's saying in part that there is no preferred form of government. So democracy, autocracy, kings, whatever, there's no preferred form of government in international law of his day. On the other hand, what he's doing here is saying what makes a government legitimate is the free choice of its people, which is a democratic impulse. So with that ambivalence, which I think is really given by the fact that in his day, the kind of democracy that we imagine now was really unthinkable, I think that this is kind of a preview to saying that the free choice by peoples of their own governments is something that international law already has said and will say a lot more about. So of course, many of the people in this room, and I think many of you will be in the footnotes of what is actually a very long article that I'm only going to talk about very briefly today, know about this debate. So back in 1992, Tom Franck, a very distinguished member of this association and someone who I know has been an inspiration to many of us, published this very influential article in the Journal of this association on the emerging right to democratic governance. And at that time, 1992, he was trying to make the case that already international law had a lot to say about democracy, to the point where he could say there was like an emerging right to democratic governance. And those of you who know the article and the debate that followed will know that he sort of pulled from three different strands of international law. One was the right of self-determination, which he defined as the right of a people in an established territory to determine its collective political destiny in a democratic fashion. And then he adduced a whole series of international law documents privileging the right of self-determination. He was interested in the rights, the political rights of opinion, expression, and association in international human rights documents, which at that time were relatively underdeveloped compared to where they are now. And then he leaned on the rights to vote and to be elected. And those rights, he thought, also involved a kind of, could open out into the monitoring of those rights through a system of election monitoring. So those were kind of the three pillars of his argument, which generated, of course, a big debate about A, whether they really existed, and B, whether it was a good thing if they existed, and C, I think everybody thought it was a good thing, but C, how would they ever be enforced? You worry about, how to put it, intervention in the name of these principles. So this has provoked a really lively debate, I think, among many of the members of this association. But it's worth recalling the moment in which Franck wrote. He wrote at this moment of tremendous optimism for the state of democracy in the world. Democracy had spread first through Southern Europe, then through Latin America, through the overturning of a lot of military dictatorships, and then when Eastern and Central Europe were allowed to break free of the Soviet Union, and then the Soviet Union collapsed. a number of states emerged out of this, and it seemed like this democratic moment. So one of the things that Tom Franck said was, underlying state practice also justifies the thought that there was an emerging right to democratic governance because every state newly freed from tyranny was choosing the path of democracy. So this is Franck's moment, this Berlin Wall falling. Fast forward to our moment. And our moment, this is Brazil. And actually our moment, this was Tel Aviv a few days ago. Demonstrations in the streets in which all of the demonstrators in all three of those demonstrations think that they're fighting for democracy. That's what they'll tell you they're fighting for. But they're fighting for very different things. So one of the dilemmas in our present moment is to ask, what is the fate of democracy now? What is democracy anyway in this very contested and polarized climate? And can international law help us sort out what the difference is between the Trump and Bolsonaro protests trying to overturn free and fair elections and the demonstrations in Israel, which are trying to preserve a democratic culture in the face of a series of laws that are designed to basically remove checks and balances from the Israeli constitutional system? Of course they're different. And my talk today is basically devoted to the proposition of saying, you have no doubt that these things are different if you look now at international law. So which democracy? And international law, I would submit, is what allows us to tell these things apart. So the question is, if we take up Tom Franck's challenge, should we rethink what the international right to democratic governance looks like if growing state practice no longer supports the thought that every government that has the opportunity to is moving in a democratic direction, right? And so this is, that's a weird word that I have there. International is growing and rising to meet the moment. Sorry, that was a little typo. And so if Tom Franck gave us Democracy 101 or 1.0, what I'm going to argue is that we're now having the right of international law, international right of democratic governance 2.0. All right, and I'm going to bookend my talk by giving you a little story about Hungary at the beginning and a little story about Hungary at the end. Those of you who know me know I can't avoid talking about Hungary, where I lived and worked for much of the 90s, and unfortunately Hungary's fate actually parallels the story that I want to tell you. So let me start with Hungary in 1989 and the uses of international law. This is the Emerging Right to Democratic Governance 1.0. This is, I'm sorry for the Hungarian, but I couldn't find the picture with English subtitles. So basically, this is the declaration of the Third Hungarian Democratic Republic in 1989. Those of you who remember or who have read about 1989 will recall that there were a number of roundtables throughout Eastern Europe that were negotiating. They were negotiations between the outgoing Communist Party, which pretty much understood it was outgoing, and incoming democratic forces of a whole variety of stripes. These negotiations in Hungary actually resulted in the drafting of a new constitution that was passed as a series of amendments to their Stalinist-era constitution, and the amendments passed on this day in the Hungarian parliament, therefore making Hungary a democracy. Behind the scenes in the constitutional drafting process, though, there were some very interesting things going on. There was a subcommittee, a constitutional subcommittee of the political committee of the roundtable, way down 3 levels, that was supposed to change enough about the Hungarian constitution to make it possible to have multi-party elections. And in the course of those negotiations, the Communist Justice Ministry, which actually had already been preparing a new constitution, said, well, look, we're only really authorized to change just enough about the Constitution to bring us to multi-party elections. But look, we know, frankly, there's going to be a lot of stuff in this Constitution we're not going to want to preserve. So let's get rid of the leading role of the Communist Party. Let's get rid of the Council of Ministers through which the party had its influence in the Hungarian government. They agree. They go through and they cross out all these things, and then they're left with not much. So they apparently sit around and look at each other and said, well, gee, this isn't much of a constitution. What can we add? And this is where, again, the idea came from, believe it or not, the outgoing Communist Justice Ministry. And they said, look, Hungary has ratified these international human rights agreements. That's already law in Hungary. Why don't we copy-paste them from the international human rights agreements directly into the constitutional text. The Communist Justice Ministry knew that the parliament which was going to pass this could hardly object because they had ratified these agreements. And the Democratic opposition was kind of surprised and said, well, sure. And so suddenly international law just copy-pasted straight in to the Hungarian constitution, at which point the Communist Justice Minister said, well, you know, back in 1964 or 63, I was a visiting student at Berkeley. And I heard some lectures from a professor there whose name was Hans Kelsen. And Hans Kelsen thought constitutional courts were a really good idea. And in fact, Austria, which had been joined at the hip with Hungary for centuries, was the first country to get a constitutional court. So I think what Hungary really needs is a constitutional court to enforce all these rights that they just put into the Constitution. The opposition, sure. They write immediately this into the Constitution, the Constitutional Court Act, all this passes. And January 1st, 1990, the new Constitutional Court of Hungary gets going, and it immediately starts enforcing all these rights by looking to, you guessed it, international law and international courts. So the Hungarian transition of 89-90 was very much what Tom Franck said. Right? Democrats in the country were willing to take international law off the rack, import it into their own constitutional text, and look to international law for guidance about how to stabilize this transition. Okay, and so that was really the emerging right of democratic governance 1.0. So why tell you this? Well, because it tells you that international law doesn't necessarily have to be enforced by international institutions. It can be there as inspiration when the moment comes in democratic transitions for people to bring this into their own system. And it operates sort of like a North Star. It gains its power from the fact that the people sitting around the table bargaining in any one country don't have the power to change it. In other words, it can't be negotiated in the course of these transitions. It acts like a North Star. It guides you regardless of where you are in the process, and its power comes from the fact that it isn't raised, it isn't a proposal from one of the parties at the table that can then be gamed, right? It's an external standard. And through this, I think, the Hungarian transition was managed. And I think a lot of the other transitions at that time also used the available international law of the day. So after all this process, what happened to Tom Franck's vision? Well, of course, in the international law literature, there was a lot of fighting over whether this was a good idea and whether he got it right and whether it was bigger or smaller or up or down from the way that he had mentioned it. But out in the world, actually, what I think we found is that all three pillars of Tom Franck's argument have now become more or less routine. So self-determination of states, you see, being actually enforced now in some parts of the world, particularly in the inter-American system, where you saw already in the 1990s OAS interventions into Haiti, Peru, Guatemala, Paraguay, and then the development of the Democratic Charter in 2001, which has provided a basis for the Organization of American States to go in and try to mediate, try to bring countries back to the rule of law. There's a lot more to be said about this, and my former student, Cassie Emmons, is here, over there, I think somewhere. There she is. Her dissertation, EMMONS, Princeton University, is a fabulous dissertation on this process in regional organizations around the world. I learned everything from Cassie on this one. So that actually is by now kind of a done deal in a lot of parts of the world. Political rights have been transformed and beefed up by transnational courts, particularly regional human rights courts, which also were kind of, they exploded in the extent and depth of their jurisprudence after Tom Franck wrote. Election monitoring is no longer controversial, and it happens in virtually every election, including, by the way, in the United States. Try assigning to your undergraduates, if you teach in the US, the election monitors reports from the US elections, and you will find a really interesting reaction. Because American elections aren't perfect, and sometimes it comes as a surprise to our students. All right, so all of this stuff is happening, right? All of those pillars are already out there. So in many ways, Tom Franck really won. Democracy promotion is everywhere. So these are some quotes from the UN Millennium Declaration. And I might also add today, is the beginning of the Summit for Democracy. It's partly here in Washington. It's also taking place in Costa Rica, the Netherlands, South Korea, and Zambia. 120 countries are included. I think 120 is like a high number for the number of democracies in the world, but we can quibble about that. But there were some that were excluded, and that was a message. Hungary, Turkey, for example. So this is also a kind of sense that democracies of the world should unite. And yet, all of this is happening against a backdrop in which all of the democracy monitoring agencies, from the Varieties of Democracy Project in Sweden to Freedom House to the Economist Intelligence Unit and lots of political scientists who study particular places, will tell you that despite all of this, democracy is in decline. Now, this is a chart that shows you 100 years of democracy, so of course it's going to look good, right? We're a lot better than 100 years ago. That said, democracies are not a whole lot better than they were 20 years ago. So there was a heady period in which lots of new democracies were formed, democracy was deepening, and then around the turn of the millennium, what we start to see is that democracy kind of goes into reverse. And the world is now, as VDEM and Freedom House both announced in their reports that just came out a month or so ago, we're now back to where we were about in 1989 in terms of the global scores of how well countries are doing in democracies. All right, so which ones? I don't know if you can see this way back there, if this is big enough, but I can give you slides afterwards if you can't see it. The question is, so who are the backsliders? And this is a little chart. Varieties of Democracy has a liberal democracy scale in which they measure separation of powers, the sort of free and fair elections, and protection of rights in a single metric. And along the horizontal axis here are the scores of every country in the world in 2012. And on the vertical axis are all the scores of those same countries 10 years later in 2022. If you're above the line, you're doing better. If you're on the line, you're the same. And if you're below the line, you're doing worse. And even if you're in the back of the room and can't see which countries all those are, you can see there's a lot more of them that are doing worse. And particularly in the top half of the scale, kind of the right half of the diagram, those were the countries that started off doing pretty well 10 years ago. And what you see is the fall of a lot of countries from off that diagonal, and how far you are off the diagonal measures kind of how far you fell. And that's just the last 10 years. The reason why Venezuela, Russia, et cetera, at the bottom is that they fell in the previous decade, right? So all of that tells you that it's also personal. You can name the countries that are actually falling in terms of their democracy scores. So what's happening? We're seeing the rise of what I call the new autocrats. And who are the new autocrats? Some of them are pictured here. But what's interesting about the way that democracies are failing is that they're not failing the old-fashioned way. They're not military takeovers, they're not coups, they're not tanks in the streets. Democracies fail now because a person with autocratic ambitions is elected, usually in a free and fair election the first time. And then they change the law. They change the Constitution, they change the fundamental structures of their state, and all of those changes have the effect of reducing constraints on the power of the leader and extending the time the leader can spend in office. And by the time you're done with a lot of those changes, you no longer really have checks and balances, and oftentimes changing the election law is part of this. And if this goes on for long enough, I have a very simple definition of democracy. Can the people get rid of their leaders when they want to? And after a certain amount of time that this goes on, the answer is no. What's striking, though, is that these new autocrats don't usually accompany this with massive human rights violations. They're not rounding up and jailing the opposition. They're not doing all the things familiar from 20th century authoritarians. This is a new script. Okay? And what's interesting is that I think autocrats are following this new script precisely because the emerging right to governance, democratic governance 1.0, has been so widely accepted that they're tiptoeing all around the edges and doing something else, right? All the new autocrats pretend to be Democrats. They all say, I am the democratic leader. I was, after all, elected. You know, tough. If you lost the election, tough. I'm the Democrat. And they don't directly attack the kind of rights that Tom Franck said were crucial to the maintenance of democracy. So, you know, yes, the press may be slanted toward the government, but there'll be a few opposition newspapers. Yes, people will not be arrested for speaking out against the government. Yes, there may be libel suits that harass them into bankruptcy, but still, the core of these rights will look like they're protected. And of course, these autocrats never cancel elections, they just rig them. And they don't rig them by stuffing ballot boxes or shooting people at the polls. They rig them by changing the laws through these, quote, democratically elected parliaments. But these new autocrats don't intend to leave office, and they will not tolerate constraints on their power, and that's where we run into trouble. And in particular, the kinds of things that were long fought for and hard won in establishing the right to democratic governance have not worked to stop these autocrats. Election monitoring has turned out to be not very helpful. I've gone back now to the election monitoring reports from all the elections that brought these new autocrats to power. And actually, I highly recommend the Carter Center's report on the 1998 election in Venezuela. Free and fair. The Hungarian election of 2010, free and fair. In other words, election monitoring, which we used to think would separate out the true Democrats from the anti-Democrats, doesn't do that anymore. And we'll see it needs to be modified and changed, but this is not helping us. And the thing is that the autocrats, though, know that if they challenge the provisions of Emerging Right to Democratic Governance 1.0, they'll get into trouble. So what they've done is they've gone to hide in the parts of the law that international law had not yet reached. In other words, they're modifying checks and balances in national constitutions. And we remember the quote from Grotius, like, we don't really care how governments are organized as long as they're the choice of the people. So we have these election monitors, they say these are the choices of the people, and then after that, okay, so Grotius needs to be updated. So here's the problem. The autocrats are now changing domestic constitutions and saying, none of your business, this is our constitution, this tells us who we are. In Europe, the phrase is constitutional identity. And so, hiding behind national constitutions, these autocrats are trying to escape the press of international law. But, and this is my good news today, international law is catching up with them. Okay, so first, international law were kind of flummoxed by backsliding. They knew what to do if there was a coup. They knew what to do if there were tanks in the streets. They knew what to do if there were mass human rights violations, and they knew what to do if there were overtly rigged elections on election day. So that's not what's happening. It took a long time. The Organization of American States took about 20 years to catch up with Chavez. The Council of Europe took about 15 years to catch up with Putin. The EU catching up with Orban after 12 years or so. So that sort of threw the international organizations off. But the courts have risen to the rescue, and some international organizations have risen to the rescue. When these autocrats come to power, the first thing they do is they attack all the institutions that can tell them no. And first in that line is the judiciary. So what happens? They try to pack the courts. They change the way that judges are appointed. They change the system for taking cases to courts, assigning presidencies, case assignments. They get involved in the mechanics of the judiciary. And so regional courts see this. Courts understand courts, and they're rising to the challenge. And we're now seeing the rise of a jurisprudence, not just of the individual right to a fair trial, but of the right to an independent judiciary, arising at almost all the regional courts. So the International Court of the Inter-American Court of Human Rights now has a jurisprudence, the Constitutional Court against Peru from 20 years ago, more recently a couple of cases arising out of Ecuador. These were cases in which constitutional and Supreme Court judges had been fired. It took a long time for their cases to percolate through the system. But as they did, the Inter-American courts developed out of the fair trial rights provision in a rights convention, the idea that you can't have a fair trial unless you have a competent and independent tribunal. And that backs up into a structural precondition of an individual right. And so the irremovability of judges and the political independence of courts is something that the Inter-American Court has been developing. Same, although very recently at the European Court of Human Rights. They started in this case out of Iceland a couple of years ago, in which they laid down, again, out of the fair trial right of Article 6, the idea that you can't have a fair trial without an independent court. And they lay out all the preconditions for knowing when you have an independent court. They did this in the case of Iceland, which is like a good country, because they saw all these cases coming along out of Poland, which has been attacking their courts and really putting, sort of what they're calling fake judges onto these courts because they're appointed strictly by the governing party, and they've displaced a lot of the sitting judges. So they set up this standard, and now they're just going through one after another. It's almost like every week the Court of Human Rights is coming out with the judgment that the Constitutional Tribunal is not properly constituted, the Civil Chamber of the Supreme Court is not properly constituted, the Disciplinary Chamber. They're working their way through the whole Polish judiciary saying, none of these are properly constituted tribunals, and therefore their decisions cannot be enforced. Wow, just in the last couple of years. The Court of Justice of the European Union has been catching up. They had a case in 2010 in which they also laid out the structural preconditions of independence of courts. And they did that seeing cases coming out of Poland, out of Hungary. And sure enough, the ECJ now has a huge jurisprudence of cases which are very critical of what Poland has done to compromise the independence of the judiciary. So we have a whole international jurisprudence now of judicial independence separate from, on top of, the individual right to fair trial. Okay, here's another area where we're starting to see some movement on presidential term limits, because again, remember, autocrats want to stay in power forever. So I think the big bang here is a decision a couple of years ago out of the Inter-American Court. It was an advisory opinion sought by Colombia on whether having term limits in constitutions was a necessary precondition of democracy. Okay, so then you're thinking, well, wait, this is a human rights court. How do they get there? And they get there by reframing the right to vote and the right to be elected and say, well, that requires an infrastructure, and there has to be able to be a rotation of power, and the longer an incumbent is in, the more you worry that this person is going to change the rules. And therefore, it's a very long and complicated opinion, but they basically say it's a requirement of democratic governance that there be term limits on the executive. And then, here too, I say the Venice Commission actually came out also with a kind of advisory opinion on this as well. So you're starting to see, courts are starting to say, no, you can't stay in power forever. They've done it in presidential systems, more complicated in parliamentary systems, but I bet it's coming. All right. Election administration. So we've seen already, it was a crucial element of Tom Franck's original proposal, that elections, that the right to vote and the right to be elected were individual rights that could be monitored by election monitors. What we're now seeing, again, the development of a very recent jurisprudence in which the regional courts are starting to say that the exercise of the individual right requires an infrastructure. And it requires an infrastructure of election administration that must itself be independent. So you see a couple of cases coming out of the Court of Human Rights in Strasbourg, in which the processing of election disputes after the fact has to be done by independent courts and not arbitrary procedures. There's a case out of Belgium a couple of years ago in which the election administration the court lays down the principle that election administration must be impartial. And actually, my favorite case is coming out of the African Court of Human Rights, which has actually struck down, as contrary to the African Charter, an election commission that was heavily weighted in favor of members of the governing party because it was not impartial. So again, you're starting to see the courts rising to the occasion and saying, what is an independent electoral administration, and how would we know it? Another development here that I find really interesting is that the thing called the European Commission for Democracy Through Law, otherwise known as the Venice Commission, which, by the way, meets in the best room in the world, and actually now has 61 member states and 9 sort of observers, partners, et cetera. And it's no longer European. So Mexico, Peru belong to it. The US actually belongs to it, so does Canada, so does Israel, for all the Israelis in the audience who are wondering about inspiration for the protests. So the Venice Commission started as a kind of group that was part of very much Tom Franck's first set of democratic changes. It was there to provide advice to democracies in transition, and gradually it's been changing its role. So now, as often as not, when it's asked to produce an opinion, it's asked to produce an opinion by the Council of Europe, the European Union, or transnational bodies that want an assessment of national law to be able to understand whether the countries in question are meeting their treaty obligations. In other words, the Venice Commission has gone from being a coach to being an enforcer, and they've really produced an impressive set of opinions. I work on Hungary. They've produced 22 opinions on Hungary in the last 12 years. Assessing various parts of this autocratic transformation, and the documents are really extremely helpful. So what we see is that these are the new resources of the right to democratic governance, 2.0, right? And what you're seeing is that out of human rights conventions, out of what looks like unpromising legal material, courts and these advisory bodies are starting to construct internationally acceptable configurations of national constitutional forms. What does it mean to have an independent judiciary? What does it mean to have an accountable executive? What does it mean to have free and fair elections? Not just whether the boxes are stuffed on election day, right? But whether the whole election administration, and one hopes soon the rules, constitute a level playing field. So all of this is developing just really in the last 10 years especially. And in some places in the EU, which has a denser jurisprudence, you actually now see a jurisprudence developing on what does it mean to have an independent central bank or an independent data protection officer. And so as you look around, the courts, advisory bodies, and transnational institutions are starting now to home in on this question of when is a constitution democratic seen from the standpoint of international law. So how do we get all this stuff to work? Well, this was one of the worries about democratic governance 1.0, right? Like, how do you enforce it? Which is always the question that bedevils many people who work on international law, including the people in this room. So I'm not talking about this. Instead, and this is where I want to give a pitch to, if you haven't discovered Manuel Cepeda's casebook on Colombian constitutional law, I really urge you to pick it up. It is just incredibly fascinating. And in fact, in many ways, my commentator got me started thinking about this, because the Colombian Constitutional Court moved very far and very deeply toward saying the domestic court said, look, our Constitution includes the constitutional text and the international law by which we are bound at the same level as the Constitution. It wasn't an international organization that brought it in. It was the court itself, and you're going to hear more about this from my commentator. But that's one of the ways international law can be used. It doesn't have to be binding. It doesn't have to be in your jurisdiction. There are ideas out there that can be brought in through national courts is one method. And Manuel Cepeda has been really my inspiration on all of this, and I've learned a ton from him, and you will too. But let me also suggest in closing that there's another way that all of this can be used. And that is when and if Democrats ever get back into power in these states that have suffered from autocratic regress, what can democracy builders do? And what I'm suggesting is that democracy builders inside states can use these developing international law principles to guide transitions back to democracy in backsliding states once they win elections. And here, I call this defending asymmetric rupture. And what do I mean by that? When these autocrats came to power, they said, we've won an election, we can do anything. And what we did was legal. Okay, so suppose the Democrats come in. In Hungary, we have this particular problem that Orban has set up the system so that if he maintains 1/3 of the seats after any election, he can block a change to almost anything. So, sometimes when the new Democrats come in, they're facing these domestic law hurdles before they can actually restore democracy. And this is where I want to say international law can tell you when you may be justified in breaking national law in order to achieve compliance with international law. In other words, a domestic transition doesn't have to be lawless, even if it violates the rules of domestic law in the way you change the law, if what you're doing is bringing it into compliance with the rule of law. And that's where I want to say moving toward autocracy is not the same as moving toward democracy. And the way you tell the difference between the protests at the Capitol here in January 2021 and in the Capitol in Brazil in 2023, take those on one side and take the movement in the streets in Tel Aviv this last 2 months, but in particular last week. One is moving toward the principles of international law, and the others are moving away. And that's exactly how you tell the difference. And so it's not tit for tat. It's not if you do it, then the other guys come in and do it the other way, right? You can get rid of all of that relativism that way. So let me close with a story about Hungarian democracy 2.0. It hasn't happened yet. But last year there were parliamentary elections in Hungary in which 6 opposition parties joined together, and I'm shaking my head because one was the former neo-Nazi party that had sort of gotten rid of its most extreme members to move a little bit toward the center, and the other was the Socialist Party that, well, it hadn't been a socialist party for a long time, but you can imagine that's the spectrum. 6 parties had to work together to try to oust Orban, given the way that he had developed election rules that made it impossible for the opposition to win an election. They couldn't agree on anything about governing, but what they agreed on was on restoring democracy. So how did they develop a common platform? This guy, Zoltán Fleck, whose picture is here, was asked to chair a committee of constitutional law professors to figure out a path forward. And the path forward they developed was to say, let's follow European law, European Court of Human Rights law, let's use international law as a blueprint for getting us out of this prison that Orban created. So they were not blinded by the constraints of domestic law that Orban had put there. They set about trying to figure out how do we enforce the decisions of these European courts that apply directly to us. How do we restore judicial independence, eliminate the surveillance state, restore freedom of religion, academic freedom, freedom of association? How do we rewrite the election laws? They went through all of these different areas, and sure enough, there were decisions that were helpful. And they developed a 100-page blueprint, and then they lost the election. Okay, so it didn't actually happen. But what you see in the difference between the resources that the Hungarian constitutional drafters used in 1989 and the ones that this group of loyal Democrats tried to use in 2022 was that the content of international law had changed so massively that now what you see is this new democratic governance material can be used by people in countries to bring democracy back. And so international law, I think, provides that path. So it's not the end, but it is the end of my talk. Thank you so much. And now my friend and commentator, Manuel Cepeda.
Good afternoon. I am so honored to be here, and since I come from Latin America, a region where we tend to speak extensively for hours, I'm going to read and try to feed my 15 minutes. So I am honored to discuss Professor Kim Lane Scheppele's Grotius lecture. I convey my gratitude to Gregory Schaffer for inviting me, as well as to Paridi Alai. It's such an honor to comment a lecture from an intellectual that I have admired since I met her at a seminar on the hardest issues coming to the chambers of constitutional judges. In her superb lecture, she raised an immense challenge to international law and to all of us lawyers. I will argue that we must take up the challenge and be prepared to endure frequent setbacks. As Winston Churchill reminded, success consists of going from failure to failure without loss of enthusiasm. Professor Scheppele is aware of the vicissitudes in any transformative endeavor, worth the struggle, as was Hugo Grotius. Both decided to confront intolerant arbitrary power as a salient feature of authoritarian governments. Grotius defied a prince in Holland who sided with the street Calvinists, the so-called Gomarists. Professor Scheppele has an impeccable record in defense of pluralism, tolerance, and liberal democracy in Hungary, Poland, and elsewhere in the European Union. The parallel goes beyond opposing arbitrary power. Both Grotius and Professor Scheppele believe in the transformative power of innovative legal arguments that in the future may become the law, as happened with freedom of the seas advocated by Grotius against the English, alas, unsuccessfully at the time. Will history also favor Professor Scheppele? I hope it does, and soon. It depends partly on us lawyers, who would have imagined that in Latin America, international law would play a democratization role, yet it has. I would like to share the broad lines and some features of this story to support Professor Scheppele's vision. Professor Scheppele rightly highlights the use of innovative economic sanctions by introducing conditionalities tied to basic principles of the rule of law and democracy. Hopefully, they work in Europe. In Latin America, they have not worked. The paradigmatic examples are Cuba and Venezuela, in two very different historical contexts. Two common factors help explain their failure: the political manipulation of economic sanctions at the internal level to stoke nationalism, the help of a great external power that eases the impact of sanctions and offers political and military support in case of geopolitical conflict. To these two factors, it should be added the selective use of corruption of internal actors to elicit support to the anti-democratic regime and the expulsion and imprisonment of political opponents. In this matter, the experience of Latin America has little to contribute. Thus, I will focus on the work of judges, as Kim said, especially the Inter-American Court of Human Rights. How can international law contribute to democracy? Professor Scheppele proposes several ways. I highlight some: preventing domestic institutions from falling victim of anti-democratic forces, to free damaged domestic institutions from autocratic capture once autocrats have locked in power, help democrats with backsliding countries, to replace autocratic and abusive law with democracy-honoring law as a way of signaling respect for the rule of law. The Latin American experience offers interesting examples of these functions of international law. The region where I came from is not an admirable example of democracy and respect for the rule of law. It has been fertile ground for dictatorships, populism, guerrilla movements, criminal organizations, terrorist actors, and all kinds of corruption. Furthermore, it is marked by structural problems of social exclusion, extreme inequality, weak domestic institutions, as well as hyper-presidentialism and attacks on judicial independence. Well, there lies its appeal. It is a region with great experience in something bad: threats and attacks on democracy. Well, these problems have been addressed in Latin America through constructive ways by the Inter-American Court. As I know that we Latin Americans tend to fall into the naive belief that the solution to a problem is to adopt a new legal rule, I quote the opinion of Armin von Bogdandy, director of the Max Planck Institute in Heidelberg, Germany. Quote, on 18 July 1978, the American Convention on Human Rights entered into force. 40 years later, it has become the cornerstone of Latin American transformative constitutionalism. Worldwide, the Convention is perhaps the most important international instrument of this nature, which begs the question of how such an extraordinary development became possible. End of quote. It became possible due to a mix of very diverse factors. One of them is that the judicial interventions of the Inter-American Court have distinctive characteristics. First, they take context very seriously. The individual facts of the case are considered an expression of that context. Second, the context is analyzed as a reflection of systemic failures. Third, the remedies adopted by the court seek an impact beyond the specific case, and may require legal and constitutional reforms at the internal level. Fourth, the court seeks, in the words of Professor Scheppele, to maintain democracy restored and discourage anyone from succumbing to authoritarian temptations again. This fourth characteristic was eloquently synthesized in the Argentine expression, nunca más, never again, which was the name of the final report of the Truth Commission chaired by the writer Ernesto Sabato. I will briefly refer to 4 areas in which the Inter-American Court has intervened to restore democracy: impunity of agents of authoritarianism, and then the power of the military, assaults on judicial independence, restrictions to media freedom, and barriers to competitive elections. I will conclude with a few reflections on the impact of its judgments. As is well known, most Latin American countries have been governed for long periods by military dictatorships. During the transitions to democracy in the mid-90s, laws were adopted in different countries to prevent dictators or members of military juntas from being tried and condemned. The Inter-American Court has consistently held that this type of laws are contrary to the American Convention of Human Rights. For example, in 2001, in the Barrios Altos judgment, the court made this very clear, and it prevented the self-amnesty adopted in Peru in the government of President Alberto Fujimori from taking effect. How seriously, being the military so powerful in Latin America, how seriously has the Inter-American Court taken the never again admonition? Very seriously. In 2011, in the Hellman versus Uruguay case, the court declared an amnesty law contrary to the American Convention. The peculiarity in this case resides not in its authoritarian origin, but in the opposite. The law had been endorsed in 2 referendums and by 3 rulings of the Supreme Court of Uruguay after the transition to democracy. The democratic pedigree of the law was unquestionable. However, for the court, never again means never again. The staunch defense of the principle according to which human rights violations by authoritarian governments, mainly military governments, cannot be forgiven fulfills a democratic function. It not only prevents key actors of dictatorships from remaining unpunished, but also sends the clear message to those who in the future ponder falling into authoritarian temptations. Professor Scheppele stresses, correctly, that in our times autocrats are subtler and more strategic. Globally, gradually, they are suppressing judicial independence and media freedom, closing the political process, and changing electoral rules to perpetuate themselves in power. All this without affecting the appearance of liberty, as citizens can continue walking down the street enjoying an ice cream. In Latin America, we have witnessed numerous attacks on judicial independence, but the Inter-American Court has intervened to try to stop them. Professor Scheppele has rightly referred to the cases of Peru and Ecuador. I limit myself to adding that in Peru, the intervention of the Inter-American Court in 2001 led to the return of the 3 justices of the Constitutional Court who had been illegally expelled from their position for having dared to take decisions contrary to President Fujimori's plan for a 3rd re-election. The other indispensable check on power in a democracy is free media. It has been attacked in the region and continues to be so, but the Inter-American Court early on made it clear that it would defend this pillar of democracy. On several occasions, the Inter-American Court has held that the contempt of laws, leyes de desacato, are contrary to freedom of the press and expression. These laws, inherited from authoritarian times, vaguely penalize disrespect for public officials. Then the court went even further. It ruled against the use of criminal law to intimidate journalists or hide facts that citizens have the right to know. It did so in 2 cases involving presidents of the Republic, Menem in Argentina and Correa in Ecuador. In the Ecuadorian case, known as Palacio Urruta, a journalist from El Universo, versus Ecuador, some NGOs argued that criminal law cannot be weaponized by public officials to prevent the disclosure of information on matters of public interest or silence democratic debate on such issues. In 2021, the court took a step in that direction, but emphasized anti-SLAPP measures. Last year, the court analyzed not the use, but the very existence and scope of the crime of defamation. In November 2022, in the Barahona Bray versus Chile case, it considered that defamation can never be applied to information or opinions on matters of public interest. The court held that, I quote, states must establish alternative mechanisms to criminal law so that public officials can obtain rectification whenever their good name or honor has been affected, end of quote. In the Ecuador case, the high-level panel of legal experts on media freedom, Coalition of States, filed an amicus curiae and welcomed the decisions. But the holding in the Barahona Bray case embraces the argument previously made by the high-level panel. At this point, allow me a brief digression on the work of the high-level panel established in 2019, to which I have the honor to belong, along with Catherine Amirfar, former president of ASIL, and Yang Jianshu, current member of ASIL's Executive Council. Both are deputy chairs of the panel, chaired by Baron David Neuberger, former president of the Supreme Court of the United Kingdom. In addition to presenting amicus curiae, the panel has begun to perform Venice Commission-style functions by rendering opinions on bills related to freedom of the press at the request of the respective state. The panel has advised states on international law, both in relation to existing framework for protection, but also addressing material gaps. The panel has issued 4 reports which have started to have an impact. For example, issue a report on the creation of an emergency visa, and several countries have accepted this report, and 1,500 emergency visas have been granted in 2022 and 223 to protect journalists. Let's go, after this digression, back to the role of international law in restoring democracy in Latin America. The Inter-American Court has also handed down rulings that keep political process open and competitive. It is a 4th way of restoring democracy. Professor Scheppele alluded to the presidential re-election without terms consultative opinion. In this advisory opinion, in 2021, the Inter-American Court held, I quote, enabling presidential re-election without term limits is contrary to the principles of representative democracy. Previously, the Colombian Constitutional Court had already decided that presidential re-election could be accepted only for 1 term. 2 consecutive terms were contrary to democratic principles and alternation in government. In addition to the perpetuation in power of the same government, there are other factors that can limit electoral competition. Can a candidate independent of the traditional dominant parties compete in presidential elections? Can a leader who has exercised opposition to the political system be disqualified from being a candidate by the imposition of a non-judicial sanction? The first question was addressed in case Castañeda-Goodman versus Mexico in 2008, and the second in López-Mendoza versus Venezuela in 2011 by the Inter-American Court, but the decisions did not have much impact in both countries. But in Colombia, both sentences were decisive for the triumph of the current president, Gustavo Petro. Since 1991, with the new constitution, adopted by a popular elected and pluralistic constituent assembly, the political system has opened to such an extent that the 2 traditional political parties refrained from controlling 92% of the seats in the Senate in 1990 to 25% in 2018. However, Gustavo Petro generated intense controversies not only for having been a former member of the guerrilla group that signed peace in 1990, but also for his political positions. I do not go into the details. I only highlight that when he was mayor of Bogota, a disciplinary sanction, that is, not a criminal one, disqualified him from being a candidate for 15 years. The Inter-American Commission tried to protect him through a precautionary measure, but it was finally the Inter-American Court who protected him, invoking inter alia the decision in the Lopez case against Venezuela. Colombian judges respected and applied the Inter-American decisions. For this reason, Mr. Petro was able to compete in 2018. Although he lost, he made it to the 2nd round of the presidential election. But his party obtained very few votes in the congressional election, thus failing below the threshold required to stay in the political game and receive state funding. However, in 2021, the Constitutional Court, invoking the principles established in the Mexican case, Castañeda, restored the legal status of his party. With this, Mr. Petro's party was able to compete in the following elections, organize a coalition, receive state funding, and finally win the presidency of Colombia in August 2022. In sum, the current president of Colombia has benefited from two judgments of the Inter-American Court, one regarding Venezuela and other regarding Mexico. This in part because Colombian judges have applied the doctrines established by the Inter-American Court by virtue of the constitutional bloc doctrine. This doctrine has been adopted in several Latin American constitutions, Colombia in 1991, Argentina in 1994, Mexico in 2011, and many others. It was differently in different countries. The constitutional bloc is the highway that allows international law to enter into the domestic sphere at the same hierarchical level of the Constitution. The bloc includes numerous international human rights treaties that can be directly applied by national judges in concrete cases. What happens with the judgments of the Inter-American Court in countries in which the doctrine of the constitutional bloc does not exist? The Inter-American Court considers that the American Convention is directly applicable regardless of whether the bloc doctrine exists in a country or not. Since the Almonacid Arellano versus Chile case in 2006, the court held that all the judges of the states parties to the convention must review the conventionality of any act relevant to decide a specific case. That is, they can determine if the national legal act is compatible with the American Convention and refuse to apply it if it is incompatible. Conventionality review has been a powerful tool to open a new entry highway for international human rights law. Monitoring compliance with its own judgments is another of the powerful tools that the Inter-American Courts has an exercise every year. These aspects of the institutional design of the Inter-American system have been paramount to enhance the impact of international law in the region. To them, we must add some features of the political and cultural context, but for reasons of time, I will just list them. First, the predominant idea that there are structural problems and systemic dysfunctions in our countries. Second, the distrust in politics and the discredit of politicians. These two elements combined have given the judiciary space to act. Third, in several countries of the region, there is a bicentennial legal tradition, and there is a community of jurists in the region dedicated to ensuring that democracy is consolidated, deepened, or protected through law, especially human rights law. I wonder which of these elements of the context help to explain the differences between what has happened in Europe and Latin America. And perhaps they will deserve more weight in Professor Scheppele's brilliant lecture. Ultimately, the challenge she raised is not only for international law, but mainly for the role of lawyers in the restoration of democracy. It may be synthesized in the following dilemma. Do we consider it legitimate that the law acquires a greater voice and role in the restoration of democracy? Or would that inevitably give too much power to the judges, and therefore it is preferable to trust the political process and give political actors the time they require? But isn't this a false dilemma? The experience of Latin America shows that there can be judicial interventions that are legally rigorous and at the time, instead of demobilizing political actors, energize pro-democratic political processes and pro-democratic laws, as Professor Scheppele invited us. Shakespeare once said, "Let's kill all the lawyers," with the nuances. Professor Scheppele tells us today, let's call all the lawyers, mainly those engaged in the defense of liberal democracy. I join in her invitation with the enthusiasm needed to keep going from failure to failure. Thank you.
So thank you, Judge Cepeda. Thank you, Professor Scheppele, for those incredibly inspiring and remarks, compelling remarks about how to bring international law home and to give concrete examples of how to do it. So thank you also for your engagement, your activism at these multiple different levels. I want to, Dean Fairfax, Professor Patty Delai, I just want to thank you for making this possible year after year. This is just an incredible way to launch this annual meeting again. I want to invite all of you to the reception. It's being hosted upstairs at the Heights Courtyard, and it's sponsored by American University Washington College of Law. So thank you very much, and I invite you to think of them as you raise your glass at the open bar. Finally, one last announcement, which is different. We're holding for patrons and for sustaining contributors immediately now in Kalorama Room, a toast to you for your assistance, your financial support for this great society. Thank you.